Hello, ladies and gentlemen. Thank you for standing by and welcome to the State of Hiring, How to Comply with Ban the Box and Other Hiring Laws webinar. Please note that during the presentation, all participants will be in a listen-only mode. If you would like to ask a question during the presentation, simply use the chat feature located on the left side of your screen. And as a reminder, this conference is being recorded Wednesday, May 6, 2015. In addition, don't forget, you'll receive a copy of the slides so you'll have all the information for future reference. My name is Stephanie Thomas and I am your host on behalf of HR Direct. Thanks for being here today. Before we get started, I have a few housekeeping items to share with you. If you experience any audio trouble, please let us know in the chat box and we'll do our best to resolve it for you. Like I said, we'll cover a lot of information and you will receive all the information in an email the next 2 days. Sorry about that. It's a lot to cover and we'll make sure to revisit it for you. While watching today's webinar, we invite you to take the conversation to social media and use the hashtag #BanTheBox on Twitter. And finally, a reminder to participate in the conversation today by asking Eric questions again on that left side of the screen. Don't be afraid, we're here to help you and we want to answer the questions for you. Without further ado, I'm pleased to introduce you to our speaker, Eric B. Meyer, partner in the Philadelphia-based law firm of Dilworth-Paxson, LLP, and publisher of the highly regarded labor and employment law blog, The Employer Handbook. I'm going to turn it over to you, Eric. Thanks for being here today.
Stephanie, thanks for having me, and thanks everyone for joining in. This looks like a really engaged audience. I like what you're all wearing today. You in the back, please put some clothes on now. But no, I'm raring to go. I was going to do my Simpsons, Troy McClure-like introduction where you may know me from such Philadelphia-based law firms as Dilworth-Paxson, LLP. But Stephanie, you've already taken care of that for me. I'll just say with respect to my blog, if you can get past the typos, the snark, and the grammar errors, there's actually a couple of good nuggets there for you, but that'll be my only plug. Let's move on and go to a poll question before I dig into today's meaty topic of Ban the Box. I'd like to get some feedback from the audience. This webinar is primarily about Ban the Box laws. So let's start things off with this poll and see how this affects you and your hiring process. So how have Ban the Box laws affected your hiring process? Applicable in your state, not applicable in your state? We updated our job applications. We want to update job applications. Not sure if and how we're covered. You can certainly pick one, multiple. There's not a choice in there where you can blame someone else if you're screwing up Ban the Box, but know that we're thinking of you. So yeah. Let's see. I'm wow. You came to the right place. Almost 50% of you are not sure if and how you're covered. Well, it's a great thing you're here today. Since most of you have answered, let's close the poll and let's move on. Thank you for participating in the poll. Now that I have a better idea of where most of you stand, it is to say you're not sure whether what law applies to you and whether the Ban the Box law applies to you. I'll kick off today's webinar. But before I do that, let me dispense with a disclaimer that I am not licensed to practice law, but I did stay at a Holiday Inn Express last night. Just kidding. I didn't stay at a Holiday Inn Express last night. I am a lawyer. I'm just not your lawyer. You see, my clients pay me, and none of you have. So nothing I say here should be construed as legal advice or creating an attorney-client relationship. Now that we have that clear, I'm going to begin by assuming that you're attending the webinar because you're stepping up your hiring this year, and you also want to learn more about Ban the Box. This is great news, mainly because it means your business is growing and you need more employees to support its growth. Let me also assume you're here because you need some information. You recognize that as you gather resources to recruit, interview, and bring on new employees, you also need to consider the hiring laws of your state, more specifically, and a big part of this webinar, Ban the Box laws. So what is the significance of Ban the Box? You've come to the right place because we'll look more closely at this aptly named legislation and what it means for you as an employer. You'll learn about the history of Ban the Box legislation, and where it's headed, in addition to important federal guidance by the EEOC, that's the Equal Employment Opportunity Commission. where I do serve as a mediator from time to time, but that doesn't give me any inside advice, any inside tips, but I'll do the best I can with you. I'll also share with you additional language and legal disclosures that may be required with your state job applications. Again, keeping in mind that what I'm giving you today is not legal advice. I'm only licensed to practice in a few states. So any questions you have that aren't resolved today, it's best to go to a local lawyer and run it by him or her. And finally, we'll cover best practices for fair hiring, under ban-the-box laws and how to reduce risk with potentially unfit candidates. So you've taken the first step. You're staying informed of ban-the-box and other hiring-related regulations in your area, whether at the state, county, or city level. The next is understanding what you can and can't do regarding criminal history inquiries and screening potential candidates. You do have options, which we're about to explore. So first off, what is ban-the-box? Okay, so why the phrase ban-the-box? Basically, it's a reference to the criminal history question on job applications. The question typically reads, have you ever been convicted of a crime? Or sometimes it reads, have you ever been convicted of a felony, with a box to check yes or no. To strike this question is to, as they say, ban the box. As a result of growing legislation, the question can no longer appear on job applications in 16 states and more than 100 cities and counties. Several large retailers such as Target, and Walmart, and Home Depot have also adopted ban-the-box policies, and just recently, Koch Industries, that's the $115 billion, I got my finger up to my mouth, my pinky up to my mouth, $billion conglomerate, announced it will stop asking stop asking applicants about criminal convictions, at least on the job application. Because of the tremendous momentum behind the ban-the-box movement, we can certainly expect more states, cities, and businesses to follow in the coming months. So let's talk about what is ban-the-box and the history of ban-the-box. The first state to pass a ban-the-box law was Hawaii, which, boy, if they ever want me to come out to Hawaii to give a spiel or a refresher course on ban-the-box, I'm right here, just holler at me. Which eliminated the question for both public and private sector employers in 1998. On a local level, Philadelphia, where I practice law, I'll make that trade Philadelphia for Hawaii in a heartbeat. Sorry, Philadelphia. No, I love it here. Philadelphia, where I practice law, I can get a good cheesesteak anytime I want. It's the first major city to to ban the box, for public and private employers in 2011. The phrase ban the box, which would come later in the early 2000s, when a group of formerly incarcerated activists coined the phrase as a rallying cry for its California-based campaign. The expression caught on and is now a common reference for any legislation that restricts criminal history inquiries on job applications. So you may be asking, does your state ban the box? Well, to date, the 16 states that now enforce this policy in some capacity are California, Colorado, Connecticut, Delaware, Georgia, Hawaii, Illinois, Maryland, Massachusetts, go Red Sox, Minnesota, Nebraska, New Jersey, where I am licensed to practice, New Mexico, Rhode Island, Vermont, and Virginia. Is your state on the list? To repeat, they are, one more time, California, Colorado, Connecticut, Delaware, Georgia, Hawaii, Illinois, Maryland, Massachusetts, Minnesota, Nebraska, New Jersey, New Mexico, Rhode Island, Vermont, and Virginia. Just an aside, you'll receive a copy of these slides and a recording of this presentation in a follow-up email, so you'll have all this information for quick and easy reference. 10 of the states that I just mentioned regulate how public employers may use criminal records. Those are California, shocking, Colorado, Connecticut, Delaware, Georgia, Maryland, Nebraska, New Mexico, Vermont, and Virginia. The other 6 states, Hawaii, Illinois, Massachusetts, Minnesota, New Jersey, and Rhode Island extend their ban-the-box laws to private employers as well. So, you may wonder how this ban-the-box legislation came about. The short answer is for reducing barriers. For the estimated 70 million, or 1 in 3 American adults with a criminal arrest or conviction, the obstacles to securing employment can be pretty tough, almost insurmountable. This legislation aims to change this by giving individuals with criminal histories a better shot at employment. Under these type of laws, you can't ask about an applicant's criminal record until the job interview, in some cases not until after the first job interview, and in some cases not until after the applicant is offered a position. Again, your state's laws, your locality's laws, the intent is the same, but the coverage varies. For example, when they were first introduced, ban-the-box laws applied only to public employers, including government contractors and subcontractors. More recently, the 6 states I mentioned a bit ago, along with the cities Boston, Baltimore, Detroit, New Haven, Indianapolis, Philadelphia, Seattle, San Francisco, and the District of Columbia, have pushed the policy out to private employers. Let me point out that just because your state doesn't enforce a ban-the-box policy, or you're not a covered employer, doesn't mean that you can explore an applicant's criminal record history, with wild abandon. Even without a legal precedent, there's something to be said for giving every candidate, criminal record or not, at least a fair chance at employment. Plus, like I already mentioned, the ban-the-box movement is growing rapidly, so there's a good chance a policy is coming to your state or local jurisdiction soon. And as we'll also discuss later, making employment decisions based on an arrest alone. So even if you don't have ban-the-box, making an employment decision based on an arrest alone, something less than a conviction, a misdemeanor, or a felony, could get you into trouble as well. Well, because we're discussing ban-the-box, the National Employment Law Project, or NELP, bears mention as well. NELP is a nonprofit organization that has partnered with advocacy groups across the country, including national organizations, work centers, policymakers, and think tanks, to fight for what it calls, quote, fair chance hiring, and otherwise create good jobs, enforce hard-won workplace rights, and help unemployed workers regain their economic footing. Well, sounds like an employee-friendly site to me. So why am I mentioning it? Why am I mentioning it here? One of its missions is to ban the box, and while they are essentially an employee rights advocate, the website is a good resource for human resources professionals to stay abreast of trends and changes in hiring laws, such as ban the box. The Department of Labor recently reported the addition of 295,000 new jobs and a 5.5% unemployment rate that's at its lowest since the spring of 2008, which you would think would be terrific news for job seekers, but unfortunately this upswing in numbers doesn't always reflect the reality for those with a criminal past, even if it's only minor convictions. Advocates are hopeful that these laws will lift the stigma attached to criminal records and force employers to review individual applicants a little more carefully. Ultimately, delaying discussions about convictions until later in the hiring process can help to level the playing field and keep the focus on a person's qualifications. It can also save you some time. So what does ban the box mean for employers? This gives you an overview of what ban the box is. What it isn't, however, is a ban on conducting a legal background check on an otherwise qualified individual. So you're not required to hire an individual with a criminal record. Instead, you must simply delay any criminal history inquiry until later in the hiring process if you are affected by ban the box. There are differences in the legislation of each state and city, which I can't cover in full in this 1-hour presentation, but the general parameters are this. First and most common, ban the box in most jurisdictions, no criminal history inquiries until after the job interview, or at least after the first job interview. Second, and more restrictive, no inquiries until after the interview or an offer of employment is made, with the understanding that an offer can be withdrawn only after consideration of the nature of the conviction, time since the conviction, and whether the conviction is directly related to the job. Sneak preview, you're going to hear a little bit more about that in a few slides when we talk about the EEOC's position on criminal background checks. Again, public employers, including government contractors, are most often affected by this legislation, but as I pointed out earlier, a handful of states have passed laws covering private employers too. Not surprisingly, this creates some confusion if you're a multi-state operation. As a general rule, I can tell you that consistency is key. So if policy dictates that you ban the box in some of the states where you do business and not in others, you may want to consider applying this across the board. Oh, I see a question. I just, out of the corner of my eye, couldn't help but notice it. We are a private employer in New Jersey. Is ban the box applicable to us? It depends. Depends how many employees you have. 10 or more employees are covered. Those employers are covered under ban the box. Getting back to the slideshow. So in safety-sensitive positions, as an employer, you may want to hire the most qualified individuals, and certainly to protect your business from potentially risky hires. So what about sensitive positions where criminal history may be more of a concern? Well, there are always exceptions to the rule, with background checks remaining a requirement under state or federal law for certain jobs. So if a background check is legally required for a position, ban the box doesn't change that fact. For example, ban the box laws often don't apply for law enforcement agencies, financial institutions, and school districts. Also exempt are positions in child care or those involving disabled, elderly, or vulnerable adults. All right, I teased it before. Here we are, EEOC guidance. Again, I'll tout for what it's worth that I'm an EEOC mediator. I've presented presentations like this with the EEOC, but let's talk about the EEOC's position on criminal histories. Beyond the specifics of state and local ban the box laws, there are other broader legal considerations to consider before peering into an applicant's criminal background. There are no federal regulations per se prohibiting you from inquiring about a criminal record. The EEOC issued a nationwide directive on the subject in 2012. In fact, if you go into and check out the EEOC's strategic enforcement plan, I'm sure it's available at eeoc.gov. I apologize, I don't have the exact URL, but if you go to eeoc.gov or if you Google it, you'll find it. Criminal history checks and disparate impact, which I'll talk about in a second, is one of the 6 enforcement priorities that the EEOC is focusing on now. In its enforcement guidance on the consideration of arrest and conviction records in employment decisions, and that is available on the EEOC website, the EEOC cautions that criminal background checks can open the door to hiring discrimination. So even stating that blatantly barring employment based solely on a conviction record, excuse me, let me say that again. The EEOC has stated that blatantly barring employment based solely on a conviction record may be unlawful under Title VII of the Civil Rights Act. So that's putting aside ban the box. There may be a separate violation under the federal law, Title VII, which protects against discrimination on the basis of a number of protected classes such as race, religion, national origin, gender, among others. Why is it unlawful? Well, largely because arrests and convictions can have a disparate impact, or put another way, an adverse effect on some racial and ethnic minorities, which can lead to racial discrimination. For example, blacks and Latinos are arrested at a rate 2 to 3 times their proportion to the general population, according to the EEOC directive. Therefore, if you routinely turn away those with criminal conviction records, and that also holds true for credit check issues, you're affecting those groups more than other applicants. Does this mean that you can't have a background check policy? No, the EEOC is definitely not saying that. What the EEOC is saying is that even though your policy may not have the intent of discriminating against certain protected classes, such as those based on race or national origin, the policy can unintentionally have a disparate impact. And if it does so, and your business does not have a business necessity for running that background check, then you may have violated Title VII of the Civil Rights Act. With that in mind, the EEOC recommends a few best practices regarding criminal records. Even if your state or city doesn't enforce ban the box rules, remove the conviction question from the job application. So ban the box effectively. After that, limit inquiries to job-related convictions as opposed to arrests, which are not proof of unlawful conduct. We'll talk about that in a little bit. And only when absolutely necessary to the business. If you encounter an applicant with a criminal record, consider the context and all the other job-related variables before making a decision. So what are we talking about there? We're talking about, as we alluded to before, the nature of the conviction, how old the conviction is, and its relatedness to the job for which you're seeking to fill. Bottom line, according to the EEOC, employers risk violating Title VII by refusing a candidate just because of a criminal conviction. Let me riff for a little bit here before I go to the next slide and just share some of my personal experience and anecdotes relating to the EEOC guidance. Like I said, I have lectured with the EEOC on this subject, and the EEOC, I can't stress enough, does take this very seriously. They continue to file lawsuits on behalf of those who are affected. Generally speaking, finding failure to hire cases to pursue under Title VII is tough because you may not know when and if your protected class has motivated an employer to make a hiring decision. But again, these are cases that are not necessarily motivated, where the employer is motivated by a protected class when making a hiring decision. So the EEOC has stepped in and is really championing the rights of those who are affected. It doesn't necessarily take someone who didn't get a job to come in and file a charge of discrimination for the EEOC to do something about it. The EEOC can file what's called a commissioner's charge and essentially do on their own what an employee hasn't initiated. So the EEOC can certainly initiate a complaint or through a commissioner's charge and then fine folks who are affected, who are disparately impacted by an otherwise neutral-looking hiring policy. The EEOC has litigated this issue, although so far it really hasn't had much in the way of success. There are two notable cases. One is the Kaplan case up in the Sixth Circuit. The other is the Freeman case in the Fourth Circuit. And to say both went horribly wrong for the EEOC would be an understatement. Both courts took issue with the methodology, the expert methodology that the EEOC attempted to employ to show that the background checks that the Freeman company and Kaplan, the testing company, had employed had a disparate impact on certain protected classes. The court absolutely tore the experts apart and dismissed the cases. That said, this remains a strategic enforcement priority for the EEOC, and I think they're going to keep coming back until they get it right. So be wary about that. Another issue, related issue that the EEOC is looking into is social media and the use of social media, not just with current employees, but also with respect to background checks and how the use of social media could relate to discrimination. Maybe not so much in the disparate impact sense, but with respect to disparate treatment, learning about someone's protected class information and making an employment decision based on that. For example, if you interview a woman sitting across to the desk from her, you would know her gender, you would generally be able to guess her race, and maybe be able to guess her age. What you might not know if she is pregnant or not, or if she has a disability or not. That's something that this woman may post on a Facebook page. And if you are an employer that, one of the few employers I've found, at least anecdotally, that uses Facebook or other social media to screen candidates, this is something you may learn. And obviously you can't make an employment decision based on learning that someone is pregnant. You can't allow that to motivate your employment decision. You can't allow someone's disability to motivate your employment decision. So the key then is a balanced approach. And so with the federal government, 16 states and 100 plus cities chiming in about the role of criminal history inquiries in the hiring process, where does this leave you as an employer? Right now, there really is no one-size-fits-all practice or strategy to satisfy the requirements in every jurisdiction. For this reason, I recommend a balanced approach that involves 3 key actions. First, as suggested by the EEOC, carefully consider if a criminal history inquiry is even necessary based on the nature of the position. Second, have a clear and consistent procedure for handling criminal record inquiries. As I've already mentioned, this is especially important if you do business or hire in more than one state. Tongue-tied here. It's so exciting. If some of those states have ban-the-box laws and others don't, it's best to delay inquiries in every hiring situation, or at least it's best to consider delaying inquiries in certain hiring situations. And use state-compliant job applications that eliminate the criminal history question, especially where you're in a ban-the-box jurisdiction. So if you hire in a state that bans the box and you're an affected employer, public or private, it makes sense to use a customized job application that doesn't ask about criminal history. However, don't assume that basic applications from major office supply retailers or something you Google online comply with the latest state-specific requirements, including mandatory disclosures and omissions. Instead, I understand from the good folks at HR Direct, this is an HR Direct presentation, I'm not being paid to say this. They offered me a sandwich. I turned them down. But I will say the good folks at HR Direct and Genial, I'm told, have attorney-approved state-compliant job applications that satisfy ban-the-box laws. If you'd offered to put some mayonnaise on that sandwich, I might have taken you up on it. But anyway, all the while supporting a hiring process that protects you from weak or high-risk candidates. In addition to capturing the meat and potatoes of a job candidate's background, education, employment history, and related skills, these applications, which I'm told are fully compliant, do the following. First, they move the Social Security number, marbles in my mouth, request to inside the form for added protection to prevent identity theft. They also include a question for soldiers returning to work in compliance with USERRA, the Uniformed Services Employment and Reemployment Rights Act. They provide legal protection against failure to hire claims by establishing a 30-day expiration date, and they include an EEOC-approved question regarding an applicant's ability to perform the essential functions of the job with or without reasonable accommodation according to the Americans with Disabilities Act, along with a general non-harassment clause. Yes, gosh, we could spend another hour or so on just the ADA component of hiring and the questions you can and can't ask and the timing of when you can and can't ask those questions, but we'll save that for another webinar. While you're updating job applications to ensure you ask the right questions, it may be time to address your full hiring process to ensure compliance. As an employer, you must display certain postings covering employee rights for prospective employees to view during the application process. In addition, reminding applicants that your business is a drug-free workplace with job application stickers and postings can reinforce your company's commitment, substance abuse policy, and create a sense of trust and safety within your company walls. I guess that wouldn't necessarily apply to every business in Colorado or Washington or Alaska or Washington, D.C. But most businesses that aren't in the marijuana industry that don't sell federal Class 1 drugs probably want to use that. Next time I'll stick to the script. As a result, you can be confident you're gathering the essential details about a candidate along with upholding the latest state hiring laws.
Hey, Eric, I think now's the time to chime in with some questions.
Yep.
You're getting a lot of questions in the chat. Thank you to everyone for participating. This is just kind of a clarification question first to make sure everyone's on the same page, everyone understands. But going back to that New Jersey question you answered earlier in the presentation, if you have employees in multiple states, but less than 10 are in New Jersey, I'm going back to that example, and 90 employees total are throughout the U.S., does the ban the box and all of this still apply? Or are you looking at number of employees that work in the specific state only?
Gosh, what is this, a law review question, law review course?
Everyone's got their own specific instances.
This is
so
true. No, that's a fair question. To the person that asked that question, please contact me offline and I'll look that up. I don't remember the answer off the top of my head. And for any questions asked today, I'm not embarrassed to say I don't know. Hopefully I don't say it too much. Gun to my head right now, I'm fairly certain that it's just employees within the Garden State, but I'm not 100% sure and I don't want to steer you the wrong way. So feel free to drop me an email after this is over, and I'll follow up on that for you.
We will have my email information and Eric's information in the follow-up email, so if you do have any questions, we will have our legal team get to you as well. So if you do have a specific concern, we will cover it for you. So my email will be in there, Stephanie Thomas, and then Eric. So you'll get some answers from either of us. We won't leave you hanging. And then we do have another question, and it's just again to clarify about financial institutions. Are they exempt from ban the box? Can we clarify this just to make sure everyone understands?
Again, another one where I apologize. I don't know the answer to that question. I would imagine that financial institutions, much like the security industry, police, public safety, things like that, there are federal regulations that require certain disclosures on the part of a job applicant. Again, gun to my head, I'm fairly certain that the banking industry, at least many positions within the banking industry, would be exempt from ban the box, but I can't sit here right now and tell you 100% for sure whether banks are excluded. Again, you can follow up with me or follow up with your local lawyer.
Okay, we got it. We'll get to you. And then for one final question before I get on with the rest of the show, just to make sure we're all on the same page, to satisfy the ban the box law, all the employer would have to do is delete the criminal history question from the job application. Can you confirm that for the audience here?
I can say this. Ban the box laws vary from state to state. If you are in a state like, well, if you're in a city like Philadelphia, where I am right now, if you were to, as they say, ban the box from the job application, but you asked about a criminal conviction in the first job interview, you have violated ban the box. So just getting rid of it from a job application obviously is a great first step, but if you're in a state or a locality where the ban the box rule is broad enough so as to preclude questions about criminal convictions in the first interview or before making a job offer, getting rid of that box isn't going to save you if that question comes up before you're allowed to ask it, if that makes sense.
Yeah, you're so right. Just make sure you identify it throughout the process. I mean, it is a process. Everyone here knows hiring is a process. There's many different stages, and we need to all approach them with a compliant mindset. So I'll let us move on, and we are getting a lot of questions. Thank you so much. We will address them, as many as we can, at the end of the webinar. I think we will have time to cover a good amount. So I'll let you take it from here, Eric.
Okay. So on state-compliant job applications, be aware that your state may have additional legal disclosures that impact your job applications. In many states, applications must include specific language about smoking, lie detector tests, volunteer work, driver's licenses, and social security numbers. Now, before I get into the examples, and I see some questions popping up in the chat box referencing particular states that I'm not licensed to practice in, I want to reassert my disclaimer. The one from the beginning of the webinar, the goofy one where I said, I'm not your lawyer, this isn't legal advice here, and I want to make clear that the examples I'm about to give are from states where I am not licensed to practice, so please consult with a local lawyer before relying upon anything I say, and that holds true for anything I've said throughout this webinar. So as for the examples, let's talk about California first, where private employers are limited in what they can ask an applicant. So a compliant job application should include a criminal question regarding sealed or expunged criminal records. More on this in a second. A statement about marijuana-related offenses and language about cases that have been judicially dismissed. Maryland is another state that has multiple disclosures, including a statement regarding lie detector tests. And in North Dakota, job apps must include a mandatory, I've never kissed a moose in my life. No, wait a minute, just making sure you're paying attention. In North Dakota, job apps must include a mandatory no smoking disclosure that reads, the company complies with North Dakota law prohibiting smoking within 20 feet of entrances and inside places of employment. Everyone knows the no moose kissing requirement is up in Alaska. Again, a reputable provider can help you with this and steer you in the right direction with your job applications. While you're updating job applications to ensure you're asking the right questions, it may be time to address a few other aspects of your hiring process. As an employer, you must display certain postings covering employee rights for prospective employees to view during the application process. In addition, reminding applicants that your business is a drug-free workplace with job application stickers and postings can reinforce your company's commitment to substance abuse policy and create a sense of trust and safety. As a result of these additional efforts, you can be confident you're gathering the essential details about a candidate along with upholding the latest state hiring laws. So let's talk about how to handle criminal background checks. How are we doing? I know we've covered a lot so far, but hopefully you have a much better understanding of ban-the-box laws at this point. If you haven't caught everything so far, again, we'll be sending out a copy of the slides in the next few days so you can review everything a second time. But moving on, I'd like to talk about the appropriate steps to take regarding those tricky criminal history discussions. To emphasize, although you can't ask about criminal history on the actual application if your state or business is affected by ban-the-box, you can broach the subject later, either at the interview stage or when extending a job offer, obviously depending on your jurisdiction and your ban-the-box law. At either of these later stages, you can ask candidates if they've been convicted. Notice I said convicted versus arrested. Be careful here. Like I mentioned earlier, an arrest is not proof of unlawful conduct, so it's generally off limits under ban-the-box laws. Depending on your state, asking about sealed or expunged records may be off limits too. For reference, expunction is a legal procedure that clears a person's criminal history and permanently seals the court file. Because of this, the prior arrest, charge, or conviction does not count towards a person's individual criminal record. Now let me throw this out there. If you are doing a job interview with an applicant and the applicant volunteers to you, whew, I'm shocked I made it to this interview today. I had so much to drink last night and spent the evening in the drunk tank at the local jail. You can certainly allow that to factor into your decision making as to whether you want to extend that person an offer. Yes, the person was only arrested, but it also speaks what this person did the night before an interview, getting really drunk and spending the night in jail, speaks to the person's responsibility and character. So certainly, although you wouldn't be able to rely upon the arrest when making an employment decision, you could certainly weigh in this person's lack of judgment in deciding not to make the offer. But once the question is out there, that is, the conviction question is out there, give applicants plenty of opportunity to explain the facts and circumstances surrounding the conviction. Not every conviction is alike, meaning it will carry different weight depending on what it is, and the position being considered. For instance, a conviction of statutory rape would certainly eliminate a candidate from a teaching position, whereas a shoplifting conviction might not hurt an applicant applying for a marketing position. And now I'd like to discuss criminal background checks. As you've learned today, you can still ask about criminal convictions as long as you do it later in the hiring process. And you can still pull a criminal history report as long as you do it later in the hiring process. In fact, background checks can be an important part of your hiring process, helping you to more carefully evaluate candidates and identify potential red flags. According to a 2012 survey by SHRM, the Society for Human Resource Management, nearly 70% of employers run criminal history checks on their potential employees. It's a pretty high number. But before you pursue a criminal history report or any other background check for that matter, like a credit report or driving record, you'll need to inform the applicant that you require it for employment and get the person's consent. This is where an attorney-reviewed and approved consent form comes into the picture, one that highlights the legal parameters to the applicant while also ensuring you're in compliance with the Fair Credit Reporting Act, or FCRA. This is the first time you're hearing about the Fair Credit Reporting Act, or FCRA. Oh, listen up, listen closely. Consent is smart for a few additional reasons. Getting permission can protect you from claims that you violated applicant privacy, and it can save you valuable HR time if applicants choose to take themselves out of the running due to things in their past they want to keep private. In any case, explain that a previous conviction does not automatically dismiss the applicant, but that someone who tries to withhold information or falsify a previous criminal record will be disqualified.
Hey, Eric.
Yes.
We have a question that I think is really perfect for right now from Beverly. She's asking, does an employee who decides to research an applicant online prior to the interview and discovers that the applicant was convicted of a criminal issue and then informs the manager, create a potential lawsuit or liability even though the employee is not involved in hiring?
Well, shout out to Beverly. Thanks for the question. The employee, is this, I'm sorry if I missed this in Beverly's question, is the employee at all involved in the hiring process?
I'm looking.
If not, I mean, presumably, as a practical matter, this is never going to come to light, because if the employee is not involved in the hiring process and finds out something about an applicant and never communicates it to the person who's making the hiring decision, I don't think anyone's going to be the wiser, if that's the question. If the employee does their own little Google search and does communicate that to the employer, let's assume it's a social media background check, that the company decides it's not going to farm out to a third party, that it's going to do itself. The company that does that check itself is not subject to the Fair Credit Reporting Act. The Fair Credit Reporting Act only comes into play when you have a third party who runs the background check, which usually happens in cases of criminal history checks and credit checks. But if you're doing a social media check, or if you're just kind of, curious and you want to go to Google, Fair Credit Reporting Act wouldn't apply. However, if there's, and I talked about it earlier, if there is protected class information about which the employer learns, the employer got to be very careful not to make a hiring decision based on that protected class information.
Beverly, we hope that answers your question.
All right. So if you use an outside source, such as a third-party agency, software program, or online service to conduct your background check, be certain it's reputable and that it operates in full compliance with the Fair Credit Reporting Act. But a word of caution, although less expensive and able to provide instant results, an online service may not be a better choice than a full-service agency, especially when it comes to matter of FCRA compliance. Additionally, if you're using a third party to conduct any sort of background check, including social media, as I said before in response to Beverly's question, the FCRA will apply. So before you initiate a background check, you'll need the relevant information about the applicant, including full name, other names used such as an alias or maiden name, current address, previous address, social security number, date of birth, driver's license number, and state, and the applicant's written authorization, as already mentioned. A typical fully comprehensive background check can cost anywhere from $50 to $150 or more. It might seem like a lot, but compare that to the cost of a bad or even dangerous hire. It's really a small price to pay if it helps you avoid high-risk hires and prevent negligent hiring lawsuits. More on that in a second, but the cost, that $50 to $150 cost, lends itself to conducting fewer background checks or being more judicious about conducting background checks, which means all the more reason to wait until you have a couple of people or one person who you're ready to give that job to conduct your background check rather than doing it early on in the hiring process. But getting back to negligent hiring, as an employer, you could be found negligent if it's revealed you were aware of the potential danger of an individual and did nothing to prevent it. So for example, let's assume you don't do background checks and hired someone with a record of violent crimes. Theoretically, you could be held liable for that if that employee hurt a customer or coworker on the job, but at the same time, if you weren't aware of the potential danger and had no reason to be aware of the potential danger, it's not as nearly as likely as you'll be found negligent. But the same concept applies to hiring drivers with bad records. So that's a situation where if you're hiring a driver, you really need to be doing, at the very least, a driving records check. And if you don't do it and that person gets in an accident, that's a situation where the company probably should have been looking into someone's driving history and may, in fact, be negligent because they have a duty to keep customers and employees safe. Once you have an applicant's criminal record, there are a number of things you can do to use the information wisely. I'd start off by stressing the importance of applying the information carefully on a case-by-case basis. I think it should be obvious by now. But the last thing you want to do is automatically dismiss an applicant because of what you're seeing in a report. Here are some questions to ask when you're reviewing an applicant's information. How long has it been since the conviction? Although the time limit for convictions varies from state to state, a decent benchmark is 10 years. Any conviction older than 10 years is probably no longer relevant to your hiring decision. What's the nature of the offense? Petty theft is one thing. First-degree murder is quite another. That's why you need to look at the severity of the crime before deciding if it's a deal breaker. What is the nature of the job? Along with the severity of the offense, you want to factor in the job itself. For example, the criteria you apply to hiring a day laborer may be quite different than that of a chief financial officer. So in this case, a traffic violation probably wouldn't have any impact on the day laborer position, whereas an insider trading conviction for the CFO would be reason for pause, or much more than that, but at the very least, pause. Also ask, does your business have certain criminal history restrictions? I mentioned this earlier, but some organizations require a clean or nearly clean criminal record, such as law enforcement agencies, certain financial institutions, school districts, and those caring for vulnerable individuals such as children or mentally or developmentally disabled adults. Make sure you understand the types of past activity that could disqualify an applicant. Put all these precautions together, and it comes down to this. You must have a clear connection, or you should certainly have a clear connection for why someone's criminal record makes him or her unfit for the job before denying the person a job. That is especially true when you're talking about something less than a felony. In states where there are state laws that restrict the use and application of criminal convictions to hiring decisions, it is easier to disqualify a candidate because of a felony. It is harder to disqualify a candidate because of a misdemeanor. It is almost impossible and probably not lawful in many states to disqualify a candidate because of a summary offense, and as we said earlier, the mere arrest would generally not be enough. This process, this evaluation process, the nature of the conviction, the timing of the conviction, the suitability for the job, these are the things that I talked about earlier with the EEOC, and it has equal application here. Similar to the approach you take when talking about an applicant's criminal conviction during an interview or job offer, if you notice something that concerns you on a criminal history report, follow up with the applicant and allow him or her to respond. Give each applicant plenty of opportunity to explain the facts and circumstances surrounding any negative information. A dedicated applicant will be prepared to explain this information along with valid reasons why it doesn't affect their ability to do the job. In fact, how the applicant handles this challenging conversation can be a strong indicator of their overall interpersonal skills, which may be helpful in your hiring decision. Allow for the possibility, too, that the report contains errors, which can be discussed in a face-to-face conversation. As it is, the Fair Credit Reporting Act requires that before you reject a job application based on information in the background check, you've got to give the applicant notice that includes a copy of the report and a summary of their rights under the Fair Credit Reporting Act. This gives the applicant the option to review the report and challenge it if necessary. Later, once you make a final decision not to hire, you must notify the applicant verbally, in writing, or electronically. I'll also note, for example, here in the Commonwealth of Pennsylvania, there's an obligation under the state law to make that notification. And I'd say writing better than verbal. All right, final notes. Let's wrap this thing up. We've reached the end. Just to wrap it up, here are the main takeaways I hope you receive from the webinar. First and foremost, ban-the-box legislation is on the rise, poised to grow quickly from the 16 states and more than 100 counties and cities that currently forbid a criminal history question on job applications. Of the 16 states with policies, 10 apply to public employers only, whereas the remaining 6 apply to both public and private employers. If you're affected by this legislation, you must wait until the interview or job offer, depending on where you are, before asking about an applicant's criminal record. At that point, you can bring up the subject, but only if you feel it's absolutely necessary to the position, and as long as you weigh the information against all the other qualifications an applicant brings to the table. Let me soften that a touch. That's more of a best practice, but certainly the timing in a ban-the-box jurisdiction is law. The same discretion is called for when you run a criminal background check, which falls under the Fair Credit Reporting Act. Although you're certainly entitled to use a criminal history report as part of your screening and hiring process, you should never unfairly dismiss or discriminate against an otherwise qualified individual. Be certain you consider the nature of the offense, how long ago it occurred, and whether it relates directly to the job. And folks, hold your applause. Hold your applause, please. This does bring us to the end of today's presentation, but I see some questions in the chat box, some that I'd like to take, some that I'm just going to ignore. But let's do our best to get to the ones that have the most universal application out there to our audience. So Stephanie,
Yes,
What looks
Eric,
good?
please go ahead. Please go ahead, and I'll let you do that. And again, if you have any questions, you can email me or Eric. I'll put that email address, both of the email addresses in the chat box. So I just want to let everyone know we'll probably go about 5 minutes past the hour. If you have to run off to a meeting, I want to thank everyone for attending today. Yes, I see more questions coming in. So I will share all that information in the chat box, everyone. And Eric, you can keep going on and roll with those questions.
Sure. Here's a question. How would you suggest actually posing the question, I guess the criminal conviction question, later in the hiring process? One is you can refrain from asking the question altogether. So if you're in a jurisdiction that allows you to ask that question after the first job interview, but before a conditional offer is made, you may want to ask it this way and say, look, we're going to run as part of this process, we're going to run a background check on you. Is there anything you want to tell us now that may come up in the background check that you wish to explain? I'd be a little bit concerned if someone doesn't disclose stuff that shows up in that ultimately shows up in that criminal history background check. But that way you're giving them a chance to explain away certain things that may show up in the background check. Question, is there guidance on how the lapse of time between candidate conviction, is there guidance on the lapse of time between candidate conviction and offer? The guidance that I've seen is from the EEOC. Now that is in the context of disparate impact, but essentially it's the longer the gap, the less significant the crime is. I mean that's kind of the most general guidance. I haven't seen it too much more specific than that. Here it is, question. New Jersey has the ban the box law. Do you mean that I cannot hire a minority with a criminal record, but I can tell a white criminal that I can't hire him due to a criminal check? Let me ask that again. Do you mean that I cannot hire a minority with a that I cannot not, there's a double negative there. Do you mean that I cannot not hire a minority with a criminal record, but I can tell a white criminal that I can't hire him due to a criminal check? Let me rephrase that. Make sure that you have a consistent policy as to what sorts of criminal convictions would disqualify someone from whatever you're hiring for. If you're hiring for a position that involves a lot of handling of money and someone has been convicted of fraud, okay, you're going to apply that across the board, whether they're white, African American, Jewish, Norwegian, male, female, disabled, over 40, it doesn't matter. So it's about having a uniform policy. Make sure, and this is crucial, that whoever's doing the hiring is aware of the policy, is trained on what questions can be asked and can't be asked during a job interview, and then just applying those rules and policies evenly across the board. I'm personally not as concerned about having to defend against a disparate impact claim as I am making sure that people with certain criminal convictions aren't hired. Certain recent, especially recent criminal convictions aren't hired given the nature of a particular position for which they are applying. Let's see what other questions we have. Let's see. The question can be asked, oh, here we go. Someone asked, the question can be asked during the first interview or after the first interview. Here in Philadelphia, it has to be, depends on the jurisdiction. Here in Philadelphia, you can't ask about a criminal convictions until after the first interview. Now, just kind of a little pragmatic practice point. That doesn't mean you bring someone in for the interview, go through the interview, and then say, interview's over, and then as they're getting up from the chair, say, all right, second interview now begins. Oh, by the way, have you ever been convicted of a crime? So no, it doesn't work like that. Check the law in the jurisdiction in which you're in. If you have a ban the box rule, and if it's like Philadelphia, you can't ask about it until after the first interview. Let's see, other questions. How are we doing on time, Stephanie?
We're good. We've got about 3 more minutes we can stay on the line if you want to keep moving on.
Okay. Here's another question. What protects a private employer from hiring someone with a criminal background when hiring within the medical field that must adhere to HIPAA regulations? Again, medical, there may be particular background screening rules that apply specifically to the medical field, to the health industry. I'm not sure how HIPAA, I don't see much interplay, maybe I'm misunderstanding the question, much interplay between HIPAA and the criminal background check. But if the question is, are there heightened background check requirements because there is access to HIPAA protected information, there may be. I'm not sure the answer off the top of my head. That's something that you can follow up with me offline, or certainly ask your local lawyer about that. Let's see, as I scroll through. If the job advertisement states ability to pass criminal background check as part of the position requirements, but the question itself isn't asked on the application, is this compliant? Oh, okay. You got to be careful about that. I think that certainly depends on the jurisdiction in which you are in. I'd be really wary about that. Posing that on a job advertisement that says you must be able to pass a criminal background check, unless you are in a regulated industry. So if you're in an unregulated industry and you put that out there, well, you're just asking for a knock on the door from the EEOC. Along those lines, those with criminal convictions need not apply. Unemployed need not apply. There are certain states that specifically ban questions like that. So that's going to be a state-to-state, city-to-city, county-to-county question. I can't really give a general answer other than I think unless you're in a regulated industry, you're putting a bullseye on yourself, an EEOC bullseye on yourself. Can a background check be administered before an offer of employment is extended? What are the parameters around these? Yeah, I mean, again, it depends on the jurisdiction in which you're in. If you're not in a ban the box jurisdiction, certainly you can do a background check before an offer of employment is extended. Although most people do it the other way, they extend the offer of employment and make it conditional on passing a background check. But if you're doing a background check before the offer of employment is extended, make sure that you are complying, among other things, with the Fair Credit Reporting Act and any other state or local laws that may apply in your jurisdiction. What other questions do we have? Do you recommend a certain company for background checks? I don't. I'm sorry. I don't not recommend any company. I'm sorry. I stick with the law. I am in California. I'm just going to skip over that question. Sorry, California. Could you please clarify all of these guidelines for criminal background checks only apply to the states that adopted ban the box, or are these general guidelines across all states? The guidelines for criminal background checks that I discussed initially in the context of ban the box, those only apply in ban the box jurisdictions. But the EEOC's jurisdiction is nationwide regardless of ban the box. So the EEOC's view on criminal background checks and how they may have a disparate impact on certain minorities, that applies in all 50 states, the District of Columbia, and in Puerto Rico. And I think in Guam too, and maybe American Samoa, I'm not sure. Fair Credit Reporting Act also applies across the country too. So even if you're not in a ban the box jurisdiction, you want to make sure that you're doing your criminal background checks in a compliant manner. And of course, as I alluded to as well, even without the federal laws and even without ban the box, there may be certain state or local laws with which you need to comply in terms of weighing criminal history in a hiring decision.
Well, Eric, I think
yeah.
that's it. Yeah, that wraps it up.
Yeah, I was going to say I'm all questioned out. It's 5 o'clock somewhere, so
we've got a very active audience here. Thank you so much to everyone for participating and asking all these great questions. I hope that you all learned a few things, one or two things maybe, from the presentation today, and how to improve your hiring practice overall with criminal background checks and making sure that your job applications are compliant with your local areas. We did try to cover as many questions as we could. Thanks again, Eric, for doing that marathon right now of all those questions. We know there are a lot of variables with Ban the Box and overall with your hiring process. So as Eric said before, make sure to check your local jurisdiction and consult with your local business lawyer when you have any follow-up questions. But if you did have anything that you really see as pertinent and you really want to talk to us about it, you can email me, Stephanie Thomas, sjthomas@hrdirect.com. I'll work with our legal team to get you an answer to make sure your hiring process is compliant. And then we've got Eric as well. Eric is a wonderful speaker today. Thank you again. Your email address I provided, Eric, to the audience as well, so they do have that. So we're here for you if you need us. A final reminder, just a few more things I want to share with you before we sign off, that you will receive a recording of the webinar from today and the slides in an email from HR Direct in 2 business days, so you should get that by Friday morning. Watch out for that. In the follow-up email as well, we're going to share with you an invite for our next webinar, June 10th. We've got John Hyman. He is another very well-respected lawyer out there, just like Eric himself.
I'm opening for Hyman? Oh, this is like opening for Seinfeld. I mean, oh, man.
We're going to celebrate National Safety Month with John, and we will have this webinar. It's applicable for all employers and all industries that would like a refresher of general safety standards according to the Occupational Safety and Health Administration, or OSHA as we all like to call them. So in next month's webinar, we'll cover steps to create an effective safety program. You'll review the new requirements that were effective as of the beginning of this year, and tips for an effective workplace safety training. So we will have that again in our follow-up email. Make sure to reach out to us if you have any follow-up questions. Thank you again to all the participants on the webinar this afternoon, and thank you again, Eric, for being here with us today. We really enjoyed it. I had a lot of fun. I hope you had a lot of fun. I think you did. I hope the audience had a lot of fun.
I did. Thank you, Stephanie. Thanks, Stephanie. Thanks, HR Direct. This was awesome. And thank you, everyone, for attending. It was a great time. Great time.
Great. Thank you. Have a great day, everyone.